Recently, two novelists filed a lawsuit against OpenAI, the company that created ChatGPT. The lawsuit claims that OpenAI's use of the novelist's books to train ChatGPT amounts to copyright infringement. This case raises some new questions about copyright law. But before we get into that, here's a brief primer on generative AI. Generative AI technology is powered by complex algorithmic systems called large language models, or LLMs. LLMs are optimized using training data. An LLM doesn't exactly incorporate verbatim copies of its training data. Instead, the LLM uses the training data to build its knowledge bank and fine-tune its ability to respond to user prompts. In this case, ChatGPT was trained on data that included the plaintiff's novels. That enabled ChatGPT to provide detailed and accurate summaries of the novels in response to user prompts. And the plaintiffs take issue with that because they didn't consent to OpenAI's use of their novels in such a way, nor are they being compensated for it. The most common defense to claims of copyright infringement is fair use. Fair use allows for the copyrighted works to be used without consent or compensation in certain circumstances. Generally speaking, if a particular use of a copyrighted work is what's called transformative, a court is more likely to consider it fair use. Here, the plaintiffs are arguing that ChatGPT's LLMs, by virtue of the fact that they incorporate information from the plaintiff's novels, are what's called infringing derivative works. Now, from OpenAI's perspective, their LLMs are transformative works because they don't include verbatim copies of the plaintiff's novels. The LLMs are also trained on other data, not just the plaintiff's novels. From the plaintiff's perspective, the LLMs are simply repackaging the information from their books. They would characterize the LLMs as more like a movie adaptation of a novel, which courts have held is just a change of form that isn't sufficiently transformative to qualify as fair use. So, is the use of copyrighted works in LLM training data a transformative use of those works? Or is it a mere change in form, more like the movie adaptation of a book? That's one of the questions that courts, legislators, and regulators will need to answer to find the right balance between encouraging innovation in AI and protecting the intellectual property rights of creators. Thanks for watching. For more, follow us on LinkedIn, Medium, and YouTube. And be sure to check out the companion article to this video. I'm Sabri Ibrahim of OptimEdge Legal.